Welcome to the launch of the UNSW Law Journal, issue 38.4, with a thematic component on enacting stigma. My name is Wei-An Tan, and I am the 2016 executive editor of the journal. Can I say it's a pleasure to see you all here. We have a fantastic turnout tonight. And in particular, I would like to extend a warm welcome to the Honourable Mr. Michael Kirby, Companion of the Order of Australia, to Peter Stevenson and the partners and solicitors of King Wood Mallesons who are joining us here tonight, to Professor David Dixon, the Dean of the UNSW Faculty of Law, and the editorial board of the journal and its alumni. At the journal, we take some pride in our status as a leading academic publication, particularly because we are entirely student-run. Every year, the journal publishes four issues, each with two parts, a general component and a thematic component focusing on a particular issue of contemporary significance. Tonight's general component exemplifies the journal's diverse contribution to legal scholarship. In its 7 articles, it covers, among other things, immigration detention, judicial diversity, and the role of literature in law. This issue's thematic component concerns the interaction between stigma and the law. It is tempting to describe stigma, or the tendency to stigmatize, as only human nature. Whether that description is apt, stigma is a readily observable part of our law. As the articles in this thematic issue show, stigma may be produced or reduced by the operation of legal systems in areas as diverse as administrative, employment, and bankruptcy law. The authors of the 5 articles in this thematic have made a valuable contribution to legal debate by examining in detail the ways in which the law inevitably encounters, counters, and reinforces stigma. In accomplishing its work, the journal relies on the very generous support and commitment of others. On behalf of the editorial board, I would like to thank our hosts for this evening, King Wood Mallesons. Amidst ongoing refurbishments on other floors, King Wood Mallesons has been most accommodating by making arrangements to provide us with this space tonight. We are honoured to have had their generous support for decades now. In particular, I thank Peter Stevenson for welcoming us here tonight, and Ella Burgess for her tireless work in organising this event. I would also like to thank our 2 other premier sponsors, Allens and Herbert Smith Freehills, for their continued support of our work. As a student journal, we are deeply grateful to our Dean, Professor David Dixon, and our faculty advisors, Associate Professors Michael Handler and Dr. Lyria Bennett-Moses, for their support and advice. Over the past year, their assistance has been invaluable. Next, our journal is its members. Thank you to the editorial board, who have voluntarily and rigorously edited every article in this issue that we see tonight, several times. I am privileged to work with such a talented group of committed editors and friends. But the person who should feel proudest tonight is Amila Pereira, the editor of this issue. Over the past year, Amila has worked tirelessly to bring this issue to completion. From call for submissions through to peer review, printing, editing, the whole process. It has not always been easy, but can I say Amila's leadership, resilience, and work ethic have been commendable throughout. I am also informed by previous executive members that Amila's talent for impersonations and accents of all sorts brought some much needed energy to those long journal meetings. So thank you, Amila. Finally, this launch marks the end of Amila's time as a UNSW law student, as she has otherwise completed her degree. Congratulations, Amila, on a remarkable job, and all the best for the future. With that, I would like to introduce Peter Stevenson, a partner in dispute resolution at King Wood Mallesons, to speak on behalf of the firm. Peter specializes in competition and consumer law, with expertise in both regulatory investigations and private enforcement, including class actions. Peter is an editor of In Competition, the first Australian law firm competition blog, and co-authors the annual Class Actions Year in Review report by King Wood Mallesons. Thank you, Peter.
Thank you, everyone. We're very pleased to welcome you here this evening as part of our continuing and very strong relationship with the University of New South Wales and in particular the Law School. Not only are we very pleased to be a premier sponsor of the journal, but we're honoured to be able to support the University and the Law School in a number of ways, including support in mooting, mediation and witness examination competitions, as well as various members of our staff lecturing in diverse fields including competition law, takeovers and securities law, financial services and insolvency, to name a few, as part of our continuing commitment to technical excellence in the law. Every year we welcome students from the University of New South Wales' summer clerks, who incidentally started with us this week, and there are some of them here tonight, as well as University of New South Wales graduates among our graduate pool. And it is a relationship that we continue to value greatly. Tonight, however, it is our particular pleasure to be able to host the launch of the latest issue of the UNSW Law Journal. In her foreword, Professor Barron notes that recent work on the concept of stigma defines it as the coexistence of labelling, stereotyping, status loss and discrimination. The concepts of unearthing and combating stigma form part of our own commitment here at KWM. We have just finalised our latest diversity and inclusion strategy, which is centred very specifically on the stigma associated with gender, culture, sexual orientation and caring responsibilities. We are also very proud of the work that we have done by both raising mental health awareness and providing accessible avenues of support as means of preventing stigma in our workplace. Mainstreaming the impacts of stigma, making it a regular feature of our workplace dialogue, is critical to making progress to counteract its effects. We therefore applaud the selection of this theme for the latest issue of the journal and welcome the editor, Amila Pereira, to speak. Thank you very much.
Thank you, Peter. Good evening. I would also like to begin by acknowledging the traditional owners of the land on which we meet, the Gadigal people of the Eora Nation, and I also pay my respects to their elders past and present. Distinguished guests, ladies and gentlemen, welcome to issue 38.4 of the University of New South Wales Law Journal. The journal is fortunate to have in each issue two distinct components, a general and a thematic. The general component of issue 38.4 contains 5 articles which broadly traverse the contemporary legal landscape. They discuss bijural inaccuracy and a comparison of Australian and English land registration systems, immigration detention, the Victorian Human Rights Charter and its effect on prisoners, literature in law, specifically looking at judicial narratives, and the historical shaping of Australian administrative law. The general component also contains a review essay that critiques 2 recently published books on judicial diversity and teamwork in courts. The thematic component also contains 5 articles, exploring how stigma and law encounter and interact with each other. I would like to dwell for a moment on the artwork that accompanies the thematic component. It is an appropriation of Goya's Saturn devouring his son. The original painting depicts the Titan Saturn who, as the story goes, so feared that his children would overthrow him that he ate them to save himself. It is a confronting image. In the appropriation, a fairly gruesome rendition of a judge is seen to be devouring the stigmatised individual. In the lead up to the launch, one UNSW law student tweeted, "Am I the only one who finds this totally disturbing?" Another Iris VP sought assurances that the image was not meant to represent the Honourable Michael Kirby, noted underneath as the keynote speaker. Certainly part of mentioning this is to reassure Mr. Kirby that this is not the case, but more importantly, the image itself is designed to be confronting. And by drawing the comparison with Goya's painting before we enter the thematic, the image invites us to wonder, is it fear that allows the stigmatised to be eaten up by the law? That is a question asked by each article in the thematic component. This issue represents the final product of many hours of hard work by many different people, all of whom are owed a debt of gratitude. First, I would like to thank Dr. Mark DeLeo, Dr. Kristen Rundle, Ms. Mara Sanroque, and Dr. Ben Golder for their helpful advice at different stages of the timeline. I'd also like to reiterate the thanks to our faculty advisors, Associate Professors Michael Handler and Lyria Bennett-Moses, and Dean Professor David Dixon. Their guidance and support of the journal is very genuinely appreciated. Of course, I wish to thank our premier sponsors, King Wood Mallesons, and Herbert Smith Freehills and Allens for their ongoing support. I would like to thank the authors. I can happily say that all the authors who appear in this issue have been a pleasure to work with, and it is a privilege to publish their articles. Professor Paula Barron has also written an outstanding foreword, and she has my warmest thanks for drawing the different threads of the thematic component so artfully together. I also thank the anonymous peer reviewers, whose considered opinions are so essential to how we make publication decisions. Wian has already said it, but the editorial board are indeed the core of the journal, and they have my deepest gratitude for editing this issue in sickness and in health, through assessments and precious free time. To the executive committee members with whom I've shared this year, Tashiana Steen, Catherine Chan, Anna Rienstra, Zhongwei Wang, Damien Morris and Bridget McManus, thank you. I have been blessed and honoured to work with such fine people. A warm thank you also to Wian Tan, who has generously assumed the mantle of executive editor for 2016 a little bit earlier than usual. My final thanks must go to three people who are very important to me, and without whose support I might well have disappeared before this issue came to fruition. To my wonderful friends, Catherine Lau, Christopher Scarf, and to my partner, Kenneth Yates, thank you for keeping my head above the water. There is one contribution to this issue that I have not yet mentioned. The Honourable Michael Kirby's contribution to this issue is twofold. Not only is he providing us with the keynote speech this evening, but we also have the privilege of publishing another speech of his, that given at the launch of the Daniel Solomons Memorial Scholarship earlier this year. In that speech, Mr. Kirby honours the memory of Daniel Solomons, a UNSW alumnus who sadly took his own life. In doing so, he draws attention to the issues of mental health and sexuality in the legal profession. As someone who, even in the process of bringing this issue together, has felt the black dog snapping at their heels, I am glad that his speech on such an important topic has found a home in this issue. I know that that sentiment will be shared by many, and I mean many, friends and peers who are either law students or already in the legal profession, many who are in this room tonight, who bear the burden in silence. It is not difficult to see how appropriately Mr. Kirby's speech sits alongside a thematic component on enacting stigma. I'm sure that for many of you, the Honourable Michael Kirby needs no introduction, but I understand such things are customary. Mr. Kirby's appointments, both judicial and non-judicial, are numerous. As a member of the Australian Judiciary, he has been a judge of the Federal Court of Australia and the President of the New South Wales Court of Appeal. Of course, Mr. Kirby served as a Justice of the High Court of Australia from 1996 to 2009. In recent years, Mr. Kirby's work with the United Nations and his contribution to the advancement of human rights has been significant. In 2013, he was appointed as Commissioner to both the UNAIDS Commission on Sustainable Health and the Commission of Inquiry on Alleged Human Rights Violations in the Democratic People's Republic of Korea. This year, he became a member of the high-level panel for the Global Fund's Equitable Access Initiative to fight AIDS, tuberculosis, and malaria. It is with great pleasure that I invite Mr. Michael Kirby to share with us his insights and deliver the keynote address.
Thank you very much, Miller, and thank you for your nice words about me. Thank you, Peter Stevenson, for having us here at King Wood Mallesons, this wonderful venue. And if this is the minor venue, one's mind boggles at the thought of what the major venue must be. And what a lovely afternoon it is out there, not so hot as yesterday, the chill winds, but the sunshine to keep us aware of our human existence. I also like to begin with an acknowledgement of the Indigenous people of our country. If we're talking about stigma, and if we're thinking about discrimination, and if we're thinking about the way in which the law has acted in a discriminatory way to put people down and reduce them, then the Indigenous people of our country are experts in that matter and still suffer many serious wrongs. I'm very pleased to see my friend the Dean here. He's always there, presiding over this magical combination of talents that is called the University of New South Wales, and in particular its law school. He is a most faithful supporter of all student activities, and as has been said, the University of New South Wales Law Journal is a student-based journal, and it retains very high standards at the decision of the student editors, who give up a lot of time. It's a very important role, and it's a great learning experience for their work that lies before them in the law. Now, I received my copy of this part of the journal, shall we say, a little late. In fact, I received it this afternoon. And I gathered there were what they call issues in the publication, which often happens. It's amazing how problems arise always at the last minute. But the benefit of this was that I then sat down and started reading the issue. There are famous book launchers who never, on principle, read the book that they are launching. The late Gough Whitlam, who was a wonderful book launcher, never ever read the books he launched, and mainly spoke about his own contributions to something peripherally relevant. Well, I'm not going to do that. But I started reading it. You may have seen I only arrived here about 5 minutes before this occasion formally began, because I found it hard to put it down. Students ask me, what is your favourite case that you decide? What's the one that sticks out in your mind? And I'm ashamed to tell them, I love them all. I love all the cases I was in. Unlike the late Justice Marr, I never had a problem of falling asleep in the High Court or in the Court of Appeal. My problem was hyperactivity and trying to go to sleep with so many interesting puzzles which the law presents to us. And of course, the issue of stigma, of which I have some little acquaintance myself, is an important element in law, in law's operation, and this part of the University of New South Wales Law Journal is important because it looks at some of the aspects of stigma which perhaps need rethinking. Last night I had to go to Canberra to take part in an event of all people, the Chartered Accountants of Australia and New Zealand, which had as its principal guest Sir Bob Geldof. And he was talking about stigma and about the stigma against various groups. And earlier in the afternoon I went to the Prime Minister and Cabinet office to speak at their invitation at the launch of their new Allies network, the LGBT and Allies network of the Prime Minister and Cabinet. And so Today, at lunchtime, I had to go to the Community Restorative Centre, of which I'm patron. That's the sort of prisoners' aid body, and that looks after the families of prisoners and prisoners themselves, and they suffer stigma. So everywhere I'm going, there's stigma in the air, and stigma is in this part, and it's not just in the thematic section. In fact, if you analyse it, the so-called general section of this part contains an opening essay by Penny Carruthers of UWA on the English land registration system, and points to the difference between the way in which the English, rather belatedly one might say about 1,000 years belatedly, have got around to having registers which provide for the availability of the documents that are key to land title, land conveyancing. But it's very different to that brilliant idea borrowed by Torrens from German lawyers in the Hanseatic League of countries, which was the idea we have in our Real Property Acts and in the Torrens system of getting title by registration. It's the register itself which is the title under our system. So it's really quite different from a facility that aids the process to a legal instrument that is the process, which is what we have. But it's a very interesting essay, but it's the only essay. Think as I might, search as I could, the idea of some stigma. I suppose there's the stigma if you're a lawyer and you lose the documents. But apart from that, I couldn't see how I could squeeze that into an overall overarching theme of stigma. But I think you could have moved the markers in this part. You could have put the marker on the stigma thematic issue immediately after Penny Carruthers' essay. All of the others have some real connection with stigma, because stigma journeys with law. The article by Desmond Manderson, whom I know from many years, is now at the ANU and was the former director of the Julius Stone Institute in the University of Sydney Law School, is called Judicial Method, Strategy and Doctrine. But fundamentally it's about law and literature, and he writes his essay about the portrayal of anguish and feelings in legal judgments, opinions of judges. And it concentrates on the very dramatic legal opinion of Dr. H.V. Evatt, Justice Evatt, when he was a Justice of the High Court of Australia, in the famous case of Chester and the Waverley Corporation in 1939, when H.V. Evatt was still a Justice of the High Court just before the beginning of the war, which led him to resign and become a politician and our Minister for External Affairs and Attorney General and President of the Third United Nations General Assembly. He was a very, very able and brilliant man. And his judgment tries to capture the feelings of Mrs. Chester when she came upon the news of her dead son's existence and end of his life. And the question was, did the law provide in those circumstances for remedies for nervous shock? And he held yes, by drawing upon literature and drawing upon the anguish of Mrs. Chester. The majority of the court held no, but rather rapidly after the decision of the majority, the legislatures enacted laws which effectively provided remedies for parents and spouses on getting news of the death of their loved ones. And there have been, of course, later decisions of the High Court in which I participated on that vexed issue of nervous shock. Justice Gageler then makes an appearance. Now, I'm getting a bit nervous about Justice Gageler. He's on his feet at this very moment at a function that the Dean and I were invited to and that I would have liked to have been there. In fact, maybe I should be down there and not here. He is there at one of the great achievements of UNSW law and UTS law, which is OSLI, the 20th anniversary of OSLI. I was there at the beginning. I pressed the button that started OSLI. I don't claim that I invented OSLI, but I was there at the beginning, and I should be down there with Justice Gageler as he's doing this. But I'm getting a bit resentful, He's turning up everywhere. He writes an essay in this part. Justice Gageler's part is Harry Whitmore and the Americans. Now, what a trendy sort of an article. What a way to give an article, and the Americans. Then he turns up in one of the other essays, in which he dilates at great length on sex. I think he's really scraping the bottom of the barrel to try to get publicity and to outflank me. And I'm very, very upset about this, but anyway, I'll try to salve my tears until later when I go home and tell my partner about this. He talks about Harry Whitmore. Now, you notice he doesn't anywhere refer to my Harry Whitmore lecture, which was a year before his and is now published in the Federal Law Review in an essay on 3 law deans. Notice how my essays are given very down-market, low-key, unadventurous sort of titles, and in that I referred to 3 law deans, including Harry Whitmore, who was a law dean at ANU and who was a very, very distinguished administrative lawyer. And law deans are definitely the subject of stigma, so this is... and Justice Gageler, as far as I'm concerned, suffers a stigma too. But these... these first 3 essays, I can't make a lot of the stigma there, but then you come to definite stigma articles. There's an article by Julie Debeljak of Monash Law School on the rights of prisoners in litigation under the Victorian Charter, the Victorian Charter of Rights and Responsibilities. Prisoners, as I certainly discovered at lunchtime today with the Community Restorative Centre, suffer a lot of stigma, and many of them, as we all know now, suffer from mental disabilities and mental handicaps. And many people are in prison because of their mental incapacity. And the attitude towards prisoners, and to some extent towards lawyers who act for prisoners, is full of stigma. And that is brought out in Julie's essay. She points out that the only real big success under the Charter was the case of a prisoner, Ms. Castles, who brought proceedings under the Charter provision for the entitlement to services without discrimination on the basis that she had asked the prison authorities to make arrangements for her to have IVF. And that was upheld by the court, that she should have that. The problem was that to get it, she would have to leave the prison. And the question was did that therefore disqualify her from the entitlement to the services? But in what one might call a generous interpretation of the Act, the Supreme Court of Victoria held, yes, she was suffering from disability under the Charter. Peter Billings of the University of Queensland wrote an essay on a group that is definitely very stigmatised, and this is people who go into detention in Australia. The would-be migrants or refugees who come to this country. It's an essay which has a lot of information about the case of Al-Kateb. Now, Al-Kateb was a very important decision where the High Court divided 4-3 concerning both the constitutionality and statutory provisions in relation to Mr. Al-Kateb as to whether they took their colour from the Refugees Convention and from universal human rights. Peter Billing's essay is an analysis of the deterrence that has been enacted in our law against refugees. It's got a 1984 equivalent word, disincentivisation, disincentive in the legislation. To disincentivise people coming from Australia, we send them to Manus Island and to Christmas Island and to other places, including, of all places, Cambodia. And we do that notwithstanding the fact that we are parties to the Refugees Convention. That would not have been possible if Al-Kateb had been decided the other way. Andrew Lynch writes an essay on, essentially, it's a review essay on women judges, and he reviews a book by Angela Rackley on the impact of women judges in the United Kingdom. And essentially it's examining the question, do women judges make a difference? And it presents the quandary. Are women judges going to make the males more agreeable? And if so, are they going to sink their differences in joint opinions where they don't stand out and you don't see their individual contributions? So that's addressing the particular stigma that women have suffered in the law, first in getting through the glass ceiling, then getting a judicial appointment, and then getting to positions of influence in the judiciary. There's then my article, which is definitely about stigma, because it's about the life and early death of Daniel Solomons. And I was glad that I was able to persuade Miller and her colleagues to include a photograph in the essay showing Daniel receiving his degree from the Chancellor of the University of New South Wales. It was his law degree, which he got with first-class honours. He had so much going for him, but he suffered from clinical depression. And research shows that lawyers have much higher professions than depression than other professions, and law students suffer much higher levels of depression, stress, and self-criticism than other students. You'd think it would be dentists, dental students or others, but it's not. It's law students, top of the pops. And it's something that is very serious and should concern everybody. It's something that should concern also big firms like this, and I'm sure it does. There is a particular essay in my article or speech in which I quoted what was seriously put forward by one of the big law firms of Sydney, I don't know which one, but somebody wrote to Lawyers Weekly afterwards, and this is what they said. Private practice lawyers are often subject to tight, client-driven deadlines and exacting internal performance targets. The competitive and confrontational nature of legal practice leaves many believing that such well-being policies are not worth the paper they are written on. A few months ago, my firm distributed helpful tips printed on colourful postcards, suggesting we ought to go for a swim in the ocean. Go home and cook a meal with your family, wrote one lawyer anonymously in 2013. Apparently, he said, the irony of recommending such fun and whimsy to a group of employees who are effectively required to remain in the office upwards of 14 hours a day for months on end was lost on the hopeful folks in human resources. Under such conditions, and with the profession's poor track record in looking after its own, cynicism is well placed. I think that's something that affects a lot of people in the law. Some of them internalise the pressure. That's what I've had to do over my life, but some of them have the pressure imposed on them. And whimsical statements like go home and cook a meal or have a swim in the ocean will sometimes fall on deaf ears. The thematic issue itself, or section itself, then begins with an excellent editorial by Miller herself, with the foreword by Paula Barron that's already been referred to. And the first article is by Isabel Carpin of UTS and Karen O'Connor of UTS. And this is on stigmatising behaviour and on the way in which the law has applied to Asperger's syndrome and to ADD syndrome, and how there's great pressure in dealing with those syndromes to try to find a biometric way of blaming it on the genes so that no one will be terribly critical of people with these syndromes because it's poor things, they can't help it, it's just in their genes. This is part of the endeavour also with sexuality to say, well, it's definitely in the genes and then you've just got to put up with it. But as with sexuality, so with Asperger's and ADD, things are never quite so simple. And the problem of putting it in the genes is that then leads to another form of stigma, which is stigma that this is a person who has a genetic disability and is therefore in some way biomarked as a less adaptable and less acceptable human being. There's a very interesting section of that essay on the case of Purvis against New South Wales Education Department, where Justice McHugh and I, in a joint opinion, dissented from the view of the majority in the High Court in relation to disability law. Brad Jessup and Claire McElraith, Brad of Monash Law School and Claire from Melbourne, provide an essay on sexual legal geography. And this is about the interesting case in which Justice Gageler wrote at great length about the provocative subject of sex. This was the case about a couple, a heterosexual couple, adult, having sex in a Nowra motel room, and whether that was covered by the doctrine of the High Court in a number of cases concerning what are activities that arise out of the employment where by reason of employment you have an overnight stay obligation. And the majority of the High Court, reversing the Federal Court, said that such activity was not something arising out of the employment, it was something that was entirely private. One can sort of understand that type of reasoning, but the views of the High Court in earlier cases, in some of which I participated, took quite a broad view about what human activity normally and reasonably goes on in breaks. And the High Court identified eating, sleeping, and attending to personal hygiene as matters that would be covered, but not a consensual adult sexual activity in which an accident happened. And the commentators in the article say that Justice Gageler has a much more realistic attitude to human relationships and sexual relationships that exist today in our society, and they rather like what he has written, but he was in the majority there and with Justice Bell. So it's an interesting question and something of a puzzle, but the suggestion is that the judges fall victim to a stereotyped attitude of what you can do and what you can't do. And the stereotype is one of marital activity and not activity of people who aren't married with nice, bright marriage certificates. Then there's an article by Angela Racusa and Philip Groves. They're both from Charles Sturt University, on bullying. And this, of course, is relevant to low self-esteem and depression and the problem of suicide. Nicola Howell and Rosalind Mason, both of QUT, have written an essay on reinforcing stigma in the case of bankruptcy, and they go through an analysis of how bankruptcy can sometimes have compulsory disqualifications, both by law and, in one case, by the Constitution. There's a provision in our federal Constitution to disqualify some people from being elected to Parliament if they've been an undischarged bankrupt. The final essay is by Pay Ali, Lucinda O'Brien, and the famous Ian Ramsey, who's the Harold Ford Professor at Melbourne Law School, on bankruptcy stigma. They trace bankruptcy law back to 1542, when the first modern Bankruptcy Act was enacted, and they go through the way in which it was created in order to discourage people from failing to pay their debts, and that it still contains that element in it, and it depends, in the view of some, in its success, to the fact that it's not a good look to get into bankruptcy and not to pay your debts, because our whole economic system operates on the assumption that people pay up and don't try to escape. But as against that, they point out that the other objectives of modern bankruptcy law include to allow people to start again, turn the page, and have a new start without undue burdens that prevent them succeeding in the economic environment where people can simply Google or look up on the bankruptcy register to see whether they have had a record in bankruptcy. So the part presents the issue which is almost universal to law, certainly very common in law, of ethics and the way in which law depends upon it operating without the sending people to jail, but simply by internalising its messages. And those messages do depend to some extent on stigma. And not all stigma is bad. The United Nations, in its work on human rights, is very reliant on stigma. And in the recent report of the Commission of Inquiry on North Korea, we didn't have any blue helmets that we could send into North Korea. We weren't even permitted, although they were urged by the Human Rights Council and the General Assembly, they wouldn't allow the Commission of Inquiry to enter. They won't allow the report of the Commission of Inquiry to their people. They won't allow their people to have access to the internet. They won't allow any form of communication of the horrors of their regime. And what does the United Nations therefore have? it has the power to report and to place the matter on the table of the General Assembly and the Security Council. But to get action beyond that, you need stigma. You need people to know how horrible the regime is and how dangerous it is, and how therefore the world has to respond to it. So some stigma is useful, and in our work on North Korea, one person said to me, if you did nothing else than have public hearings and allow so many people who have suffered to come forward, tell their stories and tell of the terrors that they suffered, that itself is a great contribution of the United Nations to honouring and respecting their fundamental human rights and to drawing the stigma of the world upon the heads of the Supreme Leader and the others in that country. So I think this is a really excellent part. I liked it so much that I couldn't stop reading it. And in fact, I have a practice of always searching to find typos, simply to show that I have read the essay very carefully. And the only one, well, it's not really quite a typo, but it's a mistake in my humble opinion. In the article on the rights of prisoners, in Julie Devilchek's article on the rights of prisoners, at page 1339, this is just to show, this is showing off. This is something Justice Gageler couldn't do. 1339, there is a passage which says, Castles was a female prisoner who wished to resume in vitro fertilisation. Now I know it's practice in some courts and with some judges to call prisoners only by their surname. And I've sat in cases where barristers acting for prisoners, or even in civil cases, come along and call their clients only by their surname. There was a case in the High Court of Australia where a very distinguished barrister came along, stood up, and the case concerned a tax case. Had nothing to do with criminal law, it was about tax. And the case was Saffron against the Commissioner of Taxation. And Mr. Abe Saffron was what was once described as a colourful Sydney racing identity. He was a person who had various allegations made against him, but I don't think many, if any, were ever brought home. And his client kept calling him Saffron. And so I said, to the mild astonishment of my colleagues on the High Court, will you humour me, please, and call your client Mr. Saffron? That is what clients are usually called in this court. And when I was on the Court of Criminal Appeal, I used to say the same thing when people referred to the prisoner as Smith or Jones. And so when I saw in a very distinguished law review dealing with the issue of stigma, Ms. Castles being described only by her surname, I thought, that is a mistake. Let it never happen again. Let us respect people who come into our courts equally and treat them before the courts with equal dignity. It's sort of a fundamental human right, and I hope that the online edition of this report will make a little change and put Ms. Castles when it first appears. But apart from that, I couldn't find a single thing I disagreed with, and I couldn't put it down, and I found it very interesting, and as I hope I've given you a little taste, a little goût of the various articles in it, they are all interesting. Aren't we lucky to be in an occupational group now increasingly called an industry, a profession which is dealing every day with puzzles. That's our blessing. We deal with puzzles, and it keeps the old grey matter working, and I love all the cases, and I loved every article, and I congratulate Miller and her team. I congratulate the University of New South Wales on another wonderful part of its splendid and outstanding law journal, and I have very much pleasure, if it is my duty to do so, to launch it upon the world and to do so with great delight, because it's something law reviews are not always. It's readable.
So, of course, I get the hard act of following that, which I think is always very unfair. So I'll keep it brief. I just wanted to say a few words of thank you, as usual. Firstly, thank you to Peter Stevenson and our friends at King Wood Mallesons for hosting us tonight and for their support of the journal and for everything else they do. The one thing, Peter, that you missed out, which is really important, is that the Mallesons is the supporter of Ross Buckley's chair in international financial law, which is a great partnership with us and which is being extended through our current project on Chinese international business and economic law. So thank you very much for that. Secondly, congratulations and thank you to Miller and the team who've put together such a great issue of this journal. There was that slightly kind of quickly passed over comment about the problems in getting this issue finalised. I'd just like to say something about that one of the real difficulties, particularly for student editors, is dealing with people who submit articles who think that their work is just the best thing in the world, and that students shouldn't dare to tell them what to do about it. That is something that's, I think it's fair to say, happened in this situation. An article has been held over, will appear later. But the point I wanted to make was just to say how very well the journal dealt with that kind of difficult problem. I think it was really well done. I guess the other thing I'll say about Miller is that she ought to win some kind of prize for the most stylish journal editor. I think we should have a prize for that. And the other thing is just about the subject matter of the special issue. It's very, very close to my heart because when I finished my law degree about 3 million years ago in England, which was the kind of law degree that all of us have reacted against in trying to make the kind of degrees that most of you guys are doing different. My experience had been so ghastly that literally the day that my finals finished, that afternoon I went to Heffer's bookshop in Cambridge and bought a big pile of books because I thought it's about time I got an education. And one of those books was Irving Goffman's Stigma. And so it's always been really important for me as one of those that set me off into criminology that I worked in for a while. And my master's thesis was actually on mental illness and social reaction theory, which is very relevant, very sadly, to the story of Daniel Solomons and a lot of the other issues which are in this journal. So it was very close to home for me. And it was a great issue of articles, not just in the special section, but throughout it, I think. And it really continues the excellent record of the journal's editors in picking really good issues, really important topical issues, and getting really good people to write about them. And again, so I'll just repeat the thing that I usually say is that people who are here from law firms, the people who are involved in our law journal are what I've been hoping it would be for a while, just like they are in the top American law reviews, that they are our best students. And it's a real mark of distinction now that for someone to be an editor of the UNSW Law Journal. So congratulations to everybody that's been involved in the journal, both this issue and throughout this year. Finally, to Michael Kirby. I'm always a bit uncomfortable, Michael, when people call you Mr. Kirby. I prefer Professor, actually. As most of you should know, I think that Professor Michael Kirby is a very very close friend of UNSW Law School, a visiting professorial fellow, and a very valuable member of my advisory council. And he amazes me always the way in which any time we ask him to do anything, he's always there, and he always does, like he's done tonight, something really wonderful. A couple of things about his speech. One was that the final point you were making was really resonated with me, that thing about the stigmatic impact of calling people just by their surnames in cases. I remember picking that up in a case which I think that you will have sat on in the High Court, Foster, which was a case about an Aboriginal man who was being detained illegally by police officers. And it was in the old days, it would have been the typical case where, well, that's the way things go, that's the way we do things. And the High Court instead called him Mr. Foster very pointedly throughout I think all of the judgments, in fact, in holding that what the police had done to him was unlawful. And it was one of the things which led to a significant change in the law. Finally, on a slightly lighter note, a thing I'm not so happy about Professor Kirby doing is talking about, God, that awful thought of Bob Geldof talking to accountants. Jesus, I must be getting old. I remember seeing Bob Geldof when he was the lead singer of a band called the Boomtown Rats, who were playing, this is even before that they were a big deal, they were playing as the backup band to some ghastly American rock band and just blew this other crowd off the stage. And now he's speaking to accountants. We're getting old. Or is that being stigmatic? Anyway, congratulations to the journal. Thank you to Mallesons, King Wood Mallesons, and thank you particularly to Professor Michael Kirby. Thank you.